GOG's authorized representative. 408. It is an issue between the parties whether GOG ever appointed such a representative. 409. So far as the terms of the EPA are concerned, the tribunal notes that a. GOG was represented by the Minister of Power or its authorized representative, emphasis added. It was not axiomatic that the minister himself, who was undoubtedly vested with authority to sign the EPA on behalf of GOG, would necessarily be the authorized representative of the GOG for the purposes of the EPA, and the appointment of whom was a specific obligation of GOG within 7 days of the signature date of the EPA pursuant to Clause 9b of the EPA. b. The definition of the authorized representative is the person named or appointed from time to time by a party and who acts on behalf of that party, and 473. c. Each of the parties was required to appoint an authorized representative within 7 days of the signing date. The role of the authorized representatives of each of GPGC and GOG was to be responsible for coordinating activities with GOG, GPGC, and resolving procedural questions that may occur during the EPA term. The authorized representatives shall be fluent in English. GOG, GPGC, shall be entitled to replace an authorized representatives by providing 7 days advance notice to GPGC, GOG, of such replacement. 410. In the opinion of the tribunal, it is evident from the particulars set out at para. 409. See above, which were equally applicable to the authorized representatives of both parties, that what was envisaged, so far as the role of the authorized representative was concerned, was that of active, hands-on, senior managerial participation in the project. It was not a mere formal or ceremonial role to be fulfilled at some remove from the performance of the project itself, and each of the parties was at liberty to change its authorized representative upon giving the prescribed notice to the other. 411. It is not open to dispute that in conformity with its obligations pursuant to Clause 8K of the EPA, GPGC appointed Mr. Andrea 474 Parasoto as its authorized representative on 8 June 2015. Whether or not GOG ever appointed an authorized representative remains an issue between the parties, but what is not in doubt is that GOG failed to make an appointment within 7 days of the date of signature of the EPA in conformity with Clause 9b of the EPA. 412. GPGC points to a. The minutes of meeting of 30 July 2015, which recorded the understanding by the parties in attendance that Mr. Francis Zada, who signed the minutes as GOG representative, would be officially appointed as an authorized representative of GOG. The minutes 475. Further recording. And a deputy authorized representative may also be appointed. b. Mr. Duncan's letter to the Minister of Power, Dr. Donker, of 18 August 2015, in which he noted that GPGC had been informed that Mr. Zada was to serve as authorized representative, but GPGC had yet to receive any formal communication from GOG in that regard. GPGC requested the formal appointment of GOG's authorized representative to enable more effective communication between GOG and 476. GPGC. C. Mr. Duncan's letter to Dr. Donker of 21 September 2015, in which, referencing previous communications, he repeated GPGC's request 477 for an official notification detailing the authorized representative of the GOG, and d. Instructions from the Ministry of Power to communicate with designated officials. First, Mr. Andrew Ashong, Mr. Zada's assistant, August 2015 to April 2016, then Mr. Ashong's successor in Mr. Zada's office, Mr. Kankam Yaboa, April 2016 to December 2016, and 478. Following the general election in December 2016, with Mr. Zada's successor as technical advisor, Mr. Michael Opam himself. 413. For its part, GOG maintains that by letter dated 2 September 2015, stated to be in reply to GPGC's letter of 18 August 2015, it appointed the Minister of Power, Dr. Donker himself, as its authorized representative in the following terms. In accordance with Clause 9b of the agreement, GOG hereby appoints the Honorable Minister of Power, Hun. Dr. Kwabena Donker as 479. Its authorized representative. 414. It is to be noted, first, that the appointment was not in conformity with Clause 9b of the EPA to the extent that it was made well outside the contractually stipulated deadline. Second, there is no suggestion that the appointment was retroactive. Rather, it purported to be made in direct response to GPGC's letter of 18 August 2015, see para. 412. B above, and third, the appointment was personal to Dr. Donker, rather than expressed as an appointment of the Minister of Power for the time being. 415. It is a curiosity of that letter, first, that Mr. Parasoto and Mr. Duncan, both of whom were questioned about it, were adamant that they had not seen it prior to its appearance in the arbitration record. Second, it is not consistent with the indication given barely a month before that Mr. Zada would fulfill the role and to which specific reference was made in GPGC's letter of 18 August 2015. Third, when Mr. Duncan wrote to Dr. Donker himself on 21 September 2015 and closed his letter by saying, "Finally, as per previous communications, we would request that we receive an official notification detailing the authorized 480 representative of GOG. He was not met with the response at the time, or at any time thereafter, that, as GOG had notified GPGC only 3 weeks earlier, the appointment had been filled by the recipient of Mr. Duncan's letter, Dr. Donker. 416. The tribunal must weigh the evidence of Mr. Parasoto and Mr. Duncan, having regard to a contemporary record which suggests that GPGC was unaware of any such appointment having been made by GOG on 2 September 2015 and that GPGC was never disabused by GOG of its belief that notification of GOG's authorized representative was still awaited as at 21 September 2015. 417. In closing submissions for GOG, reliance was placed upon, inter alia, GPGC's letters of 8 June 2015, 18 August 2015 and 21 September 2015 as evidence of its correspondence with the minister qua authorized representative, pursuant to Clause 9b, and the parties Clause 6. But that is not borne out by the content of that correspondence. The letter of 8 June was a notification to the Ministry of Power of Mr. Parasoto's appointment as GPGC's authorized representative in timely conformity with Clause 8K of the EPA. The letter of 18 August 2015 noted that GPGC had yet to receive any formal communication from GOG as to the appointment of an authorized representative and pressed for such an appointment to be made. And the letter of 21 September 2015 again requested an official notification, as per previous communications, of the appointment of GOG's authorized representative. While all of this correspondence was with the Ministry of Power, or with the then incumbent minister, Dr. Donker, it was plainly not understood by GPGC as correspondence with a formally designated authorized representative of GOG. 418. Fourth, as the tribunal has already noted, the role of the authorized representative as defined in the EPA was that of a hands-on, senior administrative function intended to ensure the smooth progress of the works. It is difficult to see how that would be compatible with the demands of high political office and a wide-ranging ministerial portfolio. 419. Fifth, Dr. Donker left office in December 2015 and it is not suggested that he was ever formally replaced in the role of authorized representative. Even as late as the 11th of September 2017, GPGC was still raising the appointment of a GOG authorized representative, in the context of a letter of which the ministry recorded receipt on 12 September 2017 and in which GPGC informed the Deputy Minister of Power that it had commenced site preparation work at the project site acquired in the TEMA Free Zones area and that activities were underway. So far as the development of a dedicated gas pipeline to the site was concerned, GPGC emphasized that it has become essential to liaise with authorized representatives from the Ministry of Energy that will be responsible for coordinating activities with GPGC and resolving procedural questions that may occur. 420. GPGC concluded. In accordance with the Ministry's obligations under the project agreement, we kindly request the Ministry to appoint authorized representatives for the above-mentioned purpose. We should be grateful to receive the names and contact details of the 481 representatives for our further action. 421. Finally, it is clear that GPGC maintained a steady flow of reports, status updates and other communications to those officials in the Ministry of Power with whom it had been instructed to communicate, and not one of them ever suggested to GPGC that it was dealing with the wrong people. Regrettably, Mr. Ashong, Mr. Kankamyaboa and Mr. Opum, all of whom were recipients of these communications, did not give evidence, and there was no opportunity to seek further clarification through them. GPGC's requests for assistance. 422. A further objection is raised by GOG that to the extent that GPGC made any requests of GOG for assistance, such requests were neither 482 clear, nor unequivocal, and they might properly be characterized as nebulous, vague and ambiguous. That is a proposition with which the tribunal has some difficulty. The complaint is simply not borne out by the record, and in any event, it is undermined by the absence of any contemporary requests for clarification on the part of GOG in respect of such applications as were made for assistance. 423. Finally, GOG maintained in the arbitration that such requests as GPGC did make were not made in conformity with Clause 28 of the EPA, which provides, in material part, that any notices desired or required to be given pursuant to this agreement shall be in writing and addressed to the party at its address as set forth on the signature page of this agreement, and shall be served I by personal delivery, or b sent prepaid by recognized courier delivery service. Emphasis added. 424. It is submitted by GPGC that a request to GOG for assistance pursuant to GOG's obligations under Clause 9 of the EPA is not among the 483 many, in excess of 20 instances in which the EPA specifically calls for the giving of formal notice. That point is compelling in the view of the tribunal, which notes, as an aside, that from October 2017 onwards, GPGC progress reports were hand-delivered to Mr. Opum in any event. 425. In the opinion of the tribunal, GOG's purported reliance on Clause 28 of the EPA is misconceived. GPGC's selection of the Blue Ocean site. 426. GOG maintains that the selection of the Blue Ocean site was an act taken outside the premise of the EPA, giving rise to a right to GOG to terminate the EPA. GPGC has submitted, rightly, in the opinion of the tribunal, that there is no provision in the EPA which would permit GOG to terminate on this basis. 427. To the extent that GOG seeks to rely on Clause 3b of the EPA to justify any such termination, the tribunal accepts GPGC's submission that the attempt is misconceived. First, Clause 3b is a provision which operates for the benefit of GPGC. It allows GPGC to determine in its sole but reasonable discretion that a site allocated by GOG is unsuitable, and that in such event, GOG is required to allocate a new site within 30 days of notification by GPGC that the original site was unsuitable. Second, if any such alternative site is likewise deemed unsuitable by GPGC, then GPGC has the option to terminate the EPA with immediate effect and to look to GOG for payment of the early termination payment and of its mobilization and other reasonable costs. Nor, in circumstances in which the unfulfilled condition precedent was a condition precedent which it was incumbent upon GOG to perform, would GOG be able to invoke Clause 3d as a basis to seek to terminate the EPA. 428. On the facts of this case, GOG withdrew the Abodze site and then, in January 2017, it withdrew the Capone site, too. Although GPGC would have been within its rights to terminate the EPA in reliance upon Clause 3b, it chose not to do so. It chose instead to identify a further alternative site. This is not a factual matrix that can be brought within Clause 3b, and the provision offers no basis upon which GOG might rely to support any such purported right of termination. It seems that by the stage of closing submissions, the emphasis of GOG's argument had shifted, such that it sought to suggest that The irrigation onto itself, by GPGC, of a site was a voluntary risk that it assumed, and such a voluntary risk, as in the Common 484 law would be described volenti non fit injuria, ought not to be rewarded with any claim for payment of compensation. 429. It is not possible either to reconcile the facts in the record with the proposition that the acquisition and development of the Blue Ocean site amounted to a clandestine endeavor of which GOG was unaware. 430. 485. Having located a prospective alternative site in late February 2017, GPGC notified the Ministry of Energy on 20 March 2017 that it had identified an alternative site for the project and consider it necessary that we formally inform you that the proposed allocation of 486. The Cape Horn site for the project did not materialize. 431. GOG acknowledged receipt of that letter on 30 May 2017. It confirmed that it had taken note of the alternative site that has been identified by GPGC for the development of the project following VRA's decision not to proceed with the leasing arrangements for the proposed Cape Horn site. 432. GOG requested GPGC to 487. Inform us about the identified alternative site and also keep the Ministry abreast with the status of the project. 433. In the meantime, however, Mr. Perisotto had prepared a project status report for GOG on 21 March 2017. It was dispatched by Mr. Caleb Ababio of GPGC to Mr. Mani. The report stated, inter alia, that GPGC, being aware of the lack of power in the country and persisting on this project, has dedicated time and further resources to identify a new and available site and have started discussion with Gridco in order to define the better solution for the high-voltage connection. A site survey around the area that belongs to Puma has been done and discussions with Gridco are ongoing pending the proposal from Gridco on how to connect the plant to the grid. Verbally, Gridco, Engineering Department, has confirmed that the connection is technically feasible and the power evacuation is possible. A geotechnical and geological survey will start next week and in parallel a technical verification, drawing the interferences between the Puma tank farms under construction and the future power station is ongoing. GPGC has performed the site survey with the engineering company that has prepared the engineering and will supply and integrate the high-voltage substation and, if required, the electrical connection between the power station and the Ghanaian national grid. 488. Due to the above, the permitting already done needs to be resubmitted especially for the permits that are site-related. 434. Mr. Perisotto also took the opportunity to report that the GPGC equipment had been dismantled and transported to Ghana where it was being stored in a temporary storage area close to Tema Port dry docks, the oversize items, and at the port containers. The tribunal will revert to this subject at paragraphs 463 to 472 below. 435. In cross-examination, Mr. Mani sought to suggest that he had been sent the report in error and that it was, in fact, an internal communication exchanged between Mr. Ababio and Mr. Perisotto. He stated that it neither merited a response, nor prompted him to seek any clarification. He had acknowledged receipt merely as a matter of courtesy. He conceded, however, that a. he had read the report, b. he had not sought any clarification of its content, and 489. c. a day after sending the letter of 20 March 2017 to the Ministry, GPGC had identified the Puma site in the report. 436. The tribunal is not persuaded by Mr. Mani's explanation and it is satisfied that the report was intended for, and read by, Mr. Mani. 437. On 20 April 2017, GGC wrote to Gridco to give formal notification of the new site and to provide Gridco with the coordinates of the 490 connection point. 438. In April 2017, Mr. Duncan attended a meeting with the Deputy Minister of Power, Mr. Adu, at which he informed him that GPGC had 491 located the Blue Ocean site and identified it as a suitable alternative. The tribunal was reminded by counsel for GPGC that Mr. Adu was scheduled to attend the hearing as an observer, but he had not been tendered as a witness, and certainly not as a witness 492. To gainsay Mr. Duncan's evidence. 439. Furthermore, the April 2017 PPA committee report identified the Blue Ocean site, noting that the GPGC project was to be located in 493. Tima. While Mr. Mani professed familiarity with the content of the report, he sought initially to suggest that its references to a site at Tima might just as well have been referring to the Cape Horn site as the Blue Ocean site, because he understood that the issue of an adequate gas supply was an issue with both sites. When it was put to him that GOG's case was that inadequate gas feed was in 494. Issue with the Blue Ocean site, Mr. Mani said that he could not speak for the Blue Ocean site. 440. In the context of its letter of 24 July 2017, submitting a draft cabinet memorandum to the Minister of Finance in which it sought the urgent approval of the tax exemptions by Cabinet and Parliament, the Ministry of Energy noted that due to challenges in finding a suitable location within the Abodze power complex, the project was relocated to a vacant land close the Cape Horn Thermal Power Plant KTPP, site in Tima. Currently, GPGC has secured a site in the Tima Free Zones Enclave for the 495 project. 441. While Mr. Mani was prepared to acknowledge that by the time that the draft was prepared, GOG knew that GPGC had secured a site in the Tima Free Zones Enclave, he was initially reluctant to concede that the reference in the last sentence of the citation could only be to the Blue Ocean site. But when pressed, he accepted that the reference could not be to the KTPP site in the penultimate sentence 496. And that he was not aware of any other site being considered in the Tima Free Zones Enclave. He was obliged to accept, too, that it was plain on the face of the draft memorandum that the need for urgency, so far as the long overdue fulfillment of GOG's condition precedent obligation to obtain parliamentary approval for the tax exemptions was concerned, was that GPGC was on the point of 497. Commencing construction. 442. Only a few days before, on 19 July 2017, the Minister of Energy had been copied on the Environmental Protection Agency's 498 environmental permit for GPGC in respect of its proposed project, located at Tima Heavy Industrial Area. 443. The AG's advice of 28 August 2017 provides further evidence of the GOG's state of knowledge. In her advice, the Attorney General noted that 499. GPGC has commenced construction on site. 444. Mr. Mani accepted that the only site at which GPGC was engaged in construction work at the time of the AG's advice was the Blue 500 Ocean site. 445. That observation was made in the context of an asserted failure on GPGC's part, reported by the Energy Commission, to obtain the requisite siting and construction permits, and which led the Attorney General to conclude that GPGC's construction activities were illegal. The tribunal deals further with this aspect of the matter, and with the Attorney General's conclusion that GPGC's failure to obtain a license pursuant to Section 11 of the Energy Commission Act left it without capacity to enter into the EPA, at paragraphs 449 to 460 below. 446. A fortnight later, GPGC notified the Minister of Power that site preparation works were underway, on the project site acquired in the 501 Tima Free Zones area, and that the development of a dedicated gas pipeline was ongoing. 447. It is Mr. Parasato's evidence that between November 2017 and January 2018, he wrote some 36 letters to, variously, VRA, the Deputy Minister of Power and Mr. Opum to keep them updated about the tender and eventual award of the gas pipeline to China Petroleum. 448. The evidence that GOG was aware of the selection and acquisition of the Blue Ocean site and of the start of construction there, and that it never raised an objection, is overwhelming. GPGC commenced construction at the Blue Ocean site without the necessary permits. 449. GOG asserts that it was entitled to terminate the EPA, because GPGC had failed to procure a provisional generation license within 30 days of the effective date, and GPGC had started construction works at the Blue Ocean site without the appropriate siting and construction permits from the Energy Commission. 450. As to the first complaint, GPGC's answer is that it could not apply to the Energy Commission for a provisional generation license until it had secured the Blue Ocean site in May 2017, because, as is common ground, such an application is site-specific. And having secured the site, GPGC applied to the Energy Commission on 31 July 2017. GPGC submitted further information requested by the Commission on the 22nd of August 2017, and on the 31st of August 2017, Dr. Ahenkora assured GPGC that the Commission was 502. Processing your application and any further requirement would be communicated to you. 451. When he wrote in those terms, however, Dr. Ahenkora was well aware that pending its return to a full complement of members after the general election, there was an hiatus in the activities of the Board of the Energy Commission between January 2017 and 20,503. September 2017. The board was the body by which applications for generation licenses were considered and approved. That being the case, one is left to search for any basis for Dr. Ahenkora's assurance that GPGC's application was being processed. 452. Further, when it was put to Dr. Ahenkora that he had made no mention in his letter of 31 August 2017 of any construction works undertaken by GPGC without the requisite siting and construction permits, he suggested that his letter was a mere acknowledgement and, we were not supposed to mention that in this letter. Dr. Ahenkora accepted that the Commission had never followed up on its letter of 31 August 2017. The next communication had been the 20th of February 2018 order to stop work. He explained that the 504 Commission had been waiting for the board to review the documentation submitted by GPGC and to approve it or not. 453. At a meeting on 13 November 2017, Dr. Ahenkora raised some additional condition precedent that GPGC had to meet before he could grant the provisional license. Notably, a letter from the Ministry of Power, Ghana Gas, confirming that gas would be allocated to the plants and an approval based on an inspection of the plants by the Ministry of Power. While he maintained that these were matters that should have been addressed before the EPA had been signed, he confirmed that once the conditions had been met, the 505 provisional license would be granted. GPGC determined to take up these matters in a meeting with Mr. Opam. 454. Dr. Ahenkora told the tribunal that he had left it to GPGC to sort out the gas supply issue with GOG and that he was unaware that the 506 GPGC equipment had been the subject of detailed due diligence, and had been accepted by GOG 2 years earlier. Once again, no mention was made of the construction work on the Blue Ocean site, but Dr. Ahenkora sought to explain that away by suggesting that the Commission had been laboring under the misapprehension that the works were actually being carried out on a different 507 work site, that of another company, AXA, which has no connection with the project. 455. What Dr. Ahenkora did not tell GPGC at that meeting, or at any time, was that the committee responsible for the PPA committee report, which he had chaired, had recommended to the Ministry of Energy that the EPA be terminated, a recommendation that he 508 professed not to recall when asked about it at the hearing. 456. In his weekly report of 30 November 2017, Mr. Parasoto recorded that GPGC had obtained its EPA permit for construction and operation, including the construction and operation of the gas pipeline. So far as the generation license was concerned, he recorded that the application had been submitted on 31 July 2017. He continued. Energy Commission have reviewed the application and requested evidence of fuel suitability and GOG review and acceptance of the equipment purchased from Italy for use in the project. GPGC wrote to GOG about the suitability of the fuel, letter ref. N.05 dated 21 September 2015, and received a copy of the report produced by the GOG team, after the visit of the power plants in Italy. GPGC has provided both of these documents to the Energy Commission but notes that the provision of fuel is not its responsibility under the EPA and that the equipment was reviewed and approved as a condition precedent to the signing of the EPA. Therefore, it feels that neither of these items should hold up issuance of the generation license. GPGC requires GOG assistance to fast-track this item. 509. Emphasis added. 457. In the course of his cross-examination, Mr. Mooney agreed that the supply of gas was a matter for GOG and that the suitability of the 510 GPGC equipment had been dealt with in 2015. 458. It is opportune to note in passing that in that same report, Mr. Perisotto recorded the extent of the progress of construction activities on the Blue Ocean site and, specifically, the status of the China Petroleum Pipeline contract. He also recorded that GPGC had obtained PURC tariff approval, its EPA permit for construction and operation, including the construction and operation of the gas pipeline, the hoarding permit and assembly district permit, and it had secured the release of the firefighting permit. 459. Mr. Perisotto noted a. that the finalization of the Gridco agreement was dependent upon the Energy Commission permit. b. delays in construction of the transmission infrastructure which could result in GPGC being ready to charge capacity before the grid connection was ready and might result in a 6-month potential impact in GPGC's commissioning schedule. c. that in the absence of any comments from GOG, GPGC had confirmed the gas pipeline parameters with China Petroleum, and d. the still outstanding tax exemptions and the finalization of the Ghana water contract in respect of both of which, he requested GOG assistance. 460. On the basis of the record as it now stands, it is apparent that even as Dr. Ahenkora was putting up further hurdles over which he required GPGC to jump in pursuit of its provisional generation license in November 2017, the Minister of Energy was about to seek the approval of the Ghanaian Parliament of a decision to terminate the EPA along with a number of other PPAs, based upon the report of the PPA committee chaired by Dr. Ahenkora. 461. The second limb of GOG's permit defense is no more meritorious than the first. It is asserted that GPGC had not been issued with a siting and construction permit from the Energy Commission, and it was on the basis that GPGC had no such permit that the 511 Commission issued its order to stop work of 20 February 2018 over the signature of Dr. Ahenkora. But first, GPGC did have a 512 building permit for the Blue Ocean site issued by the Cape Hone Catamanso District Assembly on 15 August 2017, and second, GOG has not been able to adduce any statute or regulation, including the Energy Commission Act, which addresses the requirement for any such additional construction permit. At best, it is possible to point to the Commission's 2012 License Application Manual for Service 513. Providers in the electrical supply industry, but that is stated to be a document developed to guide the Commission in the performance of its licensing obligations, and a source of information to licensed operators and prospective applicants. 462. GPGC submits, first, that there is no basis in the EPA upon which GOG could terminate that agreement by reason of the fact that GPGC was carrying out works without the additional Energy Commission permit. Second, it is difficult to reconcile the reliance placed upon this matter now, when it is clear that, as Dr. Ahenkora conceded under cross-examination, the Commission was well aware of the ongoing construction works at the Blue Ocean site, and it had informed the Attorney General that GPGC had not obtained the 514 requisite siting and construction permits, as she recorded in her AG's advice. The Commission did not take the point when it wrote to GPGC on 31 August 2017 to confirm that it was processing GPGC's application for its provisional generation license. Nor did it issue a stop order in August 2017, when the Attorney General issued the AG's advice, or even before that, when the Commission had first become aware of the construction works. In fact, as noted above, no complaint that work was going on without such an Energy 515 Commission permit was made until a week after GOG had issued its termination letter of 13 February 2018. The importation of the GPGC equipment into Ghana was premature. 463. In closing submissions, GOG maintained that GPGC's obligation to mobilize, import, install and commission the GPGC equipment could only arise after the clear approval of an effective date and due satisfaction of GOG's conditions subsequent, such that, a. Any endeavor by GPGC to import the equipment into Ghana, and require GOG to bear any expenses and consequences arising out of the importation and purported installation of the equipment in Ghana will necessarily be outside the premises of the EPA, and b. If GPGC imported the equipment into Ghana, at a time that they had not been in satisfaction of conditions precedent and conditions 516. Subsequent, the tribunal will be invited to hold that GPGC was in clear breach of clauses 6b and 8 of the agreement. 464. 517. GOG maintains that it was acknowledged by GPGC that the GPGC equipment arrived in Ghana before any land was available for it. Quite apart from the fact that GOG advances no contractual basis pursuant to which it would be entitled to terminate the EPA on such a basis, the record has established that GOG was well aware that the GPGC equipment was being imported. 465. Mr. Mani took the position that the GPGC equipment had been dismantled and shipped without prior notice to GOG and too soon. He complained that the ministry had not been privy to these developments. Rather, in the absence of any formal communication, it 518. Only got wind of the shipments when on their way. 466. That is not borne out by the contemporary record. 467. On 26 February 2016, Mr. Perisotto informed Mr. Ashong that a contract for the dismantling of the GPGC equipment in Italy had been 519. Signed. 468. In an email to Mr. Kankam Yaboa on 31 May 2016, Mr. Perisotto reported that dismantling activities in Italy have started and are proceeding on schedule. The parts of the plants that are dismantled are placed in containers and then moved to a temporary site close to the corresponding site, Trieste for Gorizia Power Plant and Livorno for Grieve 520. In Chianti Power Plant. 469. Subsequently, Mr. Perisotto told Mr. Kankam Yaboa that dismantling activities in Italy are completed 100%. And the GPGC equipment was to be shipped to Tima by special vessel for 521. Oversize items. 470. On 15 November 2016, GPGC wrote to the Minister of Power, seeking assistance in the grant of tax exemptions to clear the GPGC equipment and materials which had been imported and were expected to arrive in Ghana shortly. GPGC stated that the first 522 consignment was scheduled to arrive on the 22nd of November 2016. 471. Thereafter, on the 21st of November 2016, the Ministry of Power recorded the imminent arrival of the first consignment of the GPGC equipment and accessories in its letter to the Minister of Finance. The Ministry of Power pressed for approval of the promised tax 523 exemptions and recorded its obligation to give effect to the tax exemptions in the EPA. 472. In the course of his cross-examination, Mr. Mani accepted that no complaint had been raised by the ministry in the context of 524. GPGC's request of 15 November 2016. The AG's advice. 473. Considerable weight is placed upon the advice issued by the Attorney General of Ghana on 28 August 2017 by which she submitted to the Minister of Energy, Mr. Agyarko, her review of the PPAs, including the EPA. The purpose of the AG's advice was to enable the Cabinet to take a decision on the future of the PPAs, but to the extent that an overall impression of that advice can be obtained from the heavily redacted text produced in the arbitration, it is apparent that the premise upon which the advice was founded was that the EPA was to be terminated. The issue was to identify a legal basis upon which that might be achieved. 474. The Attorney General recorded that Ghana faced the prospect of the production of excess energy, if all of the PPAs concluded at the height of the power crisis were to be implemented as originally scheduled. The purpose of a review was to seek to alleviate the losses that might otherwise be incurred in the power sector. 475. In addition to such review by the Attorney General of the PPAs in question, of the Cabinet Memorandum of 20 June 2017 and of the PPA Committee report, the basis of her conclusions is said to be information attributed to the Energy Commission, the absence of a Section 11 Energy Commission Act license, and established Energy Commission policy. The latter apparently required a contractor to obtain siting and construction permits from the Commission and prohibited the deployment of a used plant. The AG's advice further references the conditions precedent provisions of the EPA, citing Clause 3D, in particular. It contained the bold statement that, although CPs have not been performed, there is also no evidence that the effective date has been extended by mutual agreement by the parties. 476. That statement is wrong to the extent that there is no provision in Clause 3 of the EPA for the extension of conditions precedent by mutual agreement. Pursuant to Clause 3c, it is the prerogative of the party not responsible for the fulfillment of a condition precedent to grant an extension. 477. So far as the conditions subsequent are concerned, the Attorney General referenced Clause 4g of the EPA, noting that any termination based upon that provision had to arise out of a non-fulfillment of the condition subsequent, wholly attributable to GPGC, and it gave rise to a liability, in the event of a breach of obligation or a default on GPGC's part, to pay the early termination fee to GOG pursuant to Clause 25b(e). 478. Without any further reasoning, the Attorney General concluded that GOG had the right lawfully to terminate the EPA on the grounds of a. Illegality for want of capacity of GPGC to enter into a PPA. b. Failure to obtain siting and construction permits. c. Installation of used plant contrary to policy, and d. Failure on the part of the seller to fulfill its CPs and conditions subsequent. 525. And that if GOG were to terminate the EPA on the final of those four grounds, it would be entitled to the early termination fee. 479. Whether or not Dr. Ahenkora's evidence to the tribunal was correct, when he testified that none of the information said by the Attorney General to have been elicited on inquiry of the Energy Commission was provided directly by the Commission to the Attorney General. Rather, all correspondence had been between the Commission and the Ministry of Energy. It is evident on the record available in this arbitration that the premises upon which the AG's advice was founded did not reflect the true facts. First, as Dr. Ahenkora was obliged to concede, the Board of the Energy Commission, which was the body charged with approving a provisional generation license, had not been reconstituted when GPGC had submitted its application in July 2017. That remained the case at the time that the Attorney General was preparing her advice. Second, GPGC did have a building permit for the Blue Ocean site issued by the Capone Catamanso District Assembly, and GOG has not been able to adduce any statute or regulation, including the Energy Commission Act, which addresses the requirement for any additional construction permit. Third, the nature of the GPGC equipment to be used for these works was expressly described in the EPA, and it had been inspected and approved for use by the Ministry in June 2015. Fourth, the extent of the interplay between the obligations of the parties, so far as their respective conditions precedent and conditions subsequent were concerned, has been considered in some detail above. 480. The tribunal must respectfully disagree with the AG's advice. It has found that there is no basis for GOG's contention that it has established an entitlement to terminate the EPA pursuant to Clause 4g of the EPA. GOG's asserted right to terminate the EPA pursuant to Clause 24d. 481. Clause 24d provides that, upon the occurrence of any GPGC default, the GOG may I. terminate this agreement, or e. exercise any other right or remedy which may be available to the GOG under any applicable law. 482. But if this argument is to succeed, GOG must establish that GPGC was in default under the terms of Clause 24 CI, that GOG had provided GPGC with a written notice of the nature of the breach and of its intention to terminate as a result of the breach, and that GPGC had failed to commence to cure the breach or to provide reasonable evidence that no such breach had occurred within 30 days of receipt of the notice. None of those conditions was met in this case, to the point that the letter of termination of 13 February 2018 was based on a purported reliance upon Clause 4G of the EPA. No reference whatever was made to a Clause 24 CI default. Mutual breach. 483. At paragraph 76 of its rejoinder, GOG advanced the contention that the parties mutually breached the EPA and in that event must be discharged from their respective obligations. 484. GPGC dismisses this argument on the basis that no legal authority has been suggested in support of that contention and that there is none. The tribunal accepts that submission. No acceptance of GOG's repudiation within a reasonable time. 485. In response to this complaint, GPGC advances the uncontroversial proposition that what constitutes a reasonable time is determined by the facts and matters of the particular case and that in evaluating what a reasonable time might be, an innocent party does not lose its right of termination by investigating the repudiation and calling upon the other party to remedy it. As counsel for GPGC put it, GPGC clearly did exercise its right to terminate within a reasonable time. It immediately made several entreaties to GOG to remedy the situation, and in response to these requests, senior government officials assured GOG that the purported termination was 526. Misguided and would be retracted. 486. The record before the tribunal bears out that submission, in particular the following. A. On 13 March 2018, GPGC was told that the Minister of Energy would advise Mr. Adu, Deputy Minister of Power, to write a memo to the President and the Cabinet of Ministers to seek the reinstatement of the EPA. B. On 16 March 2018, in the course of a meeting between representatives of GPGC, led by Mr. Duncan, and Deputy Minister Adu, the latter assured GPGC that efforts were underway to reinstate the EPA. C. On 4 April 2018, Mr. Adu informed GPGC that the President of Ghana had verbally approved the reinstatement of the EPA and instructed the Energy Commission and Mr. Opum to ensure that GPGC could resume construction, as it did on 24 April 2018, and D. On 3 May 2018, in response to its letter of 26 February 2018, GOGC was told that the Ministry is working on the issues raised in your 527 letter and will revert to you soon with our response. 487. Mr. Adu was not made available to give evidence about these matters, but on the basis of this record, the tribunal concludes that once it had become clear that GOG would not retract its termination notice, GPGC's acceptance of GOG's repudiation of the EPA was 528. Timely and proper. Conclusion. 488. On the basis of the record before it, the tribunal is satisfied that the die was cast for the EPA once the PPA committee report had reached the conclusion that the projected capacity additions from the PPAs were far in excess of the required additions inclusive of a 20% system reserve margin from 2018 to 2030. 489. Its recommendation was to defer 4 PPAs with a combined capacity of 1,810 megawatts to 2018-2025, defer 3 PPAs with a combined capacity of 1,150 megawatts beyond 2025, terminate 11 PPAs with a combined capacity of 2,808 megawatts, and allow the remaining PPAs to proceed without modification. GOG anticipated significant savings from these deferments and terminations. The estimated cost for the terminations is $402.39 million United States dollars, compared to an average annual capacity cost of $586 million United States dollars each 529 year, or a cumulative cost of $7,619 billion United States dollars from 2018 to 2030. 490. One of the PPAs recommended for termination was the GPGC project. Dr. Ahenkora's committee suggested that termination could be achieved for some 18 million United States dollars as opposed to payments of 24.9 million United States dollars a year for 4 years in excess capacity charges. The basis of that recommendation is not known. The copy of the PPA committee report submitted into the record by GOG is heavily redacted, notwithstanding the tribunal's order that the unredacted text be disclosed. Under cross-examination, Dr. Ahenkora 530 equivocated as to whether he had any recollection of the particular recommendation made in respect of the GPGC EPA at all, just 531. As he had sought to distance himself from the AG's advice of August 2017. 491. False assurances were given by GOG in October 2017 that the GPGC project was one of those unaffected as a result of the review, and 532. That it enjoyed the full support of the Minister and of Mr. Opam. 492. On the basis of this record, the Tribunal has no hesitation in concluding a. That the true reason for the purported termination of the EPA was aptly summarized by counsel for GPGC in the course of his opening submissions. The PPA committee report suggested that the actual development cost of the project to date should be verified and used as a guide in negotiations for termination. In other words, the committee suggested that GOG should negotiate a settlement under which it would only compensate GPGC for its actual development costs rather than what GPGC was entitled to under the contract. The committee calculated what it estimated that actual development cost to be, and thus the hoped-for price of a negotiated termination might be 18 million United States dollars. GOG's sole reason for terminating the GPGC contract was that its faithful performance would be expensive, that all of the electricity generated would be excess, and that GOG thought it could negotiate a settlement based on termination against a payment of $18 million. So this was a cost-benefit analysis pure and simple, given a coating of legal veneer by the AG's advice. And that b. GOG's defense based upon Clause 4(g) of the EPA must fail. 493. In light of those conclusions, the Tribunal must consider the proper measure of damages to which GPGC is entitled by reason of GOG's wrongful termination of the EPA. 494. Recital F of the EPA records that the GOG recognizes that by GPGC dedicating exclusively the GPGC equipment for the purpose of this EPA, the performance of the term is of the essence of the EPA, as GPGC will be unable otherwise to make good any loss suffered. 495. Clause 2(b) of the EPA provides that the term shall be a guaranteed period, and in the event this EPA is terminated in accordance with the provisions thereof prior to its scheduled expiration date as a result of the default of any of the parties, the party not responsible for the default may proceed in accordance with Clause 25 of this agreement. 496. If GPGC is right and GOG repudiated the EPA, such that GPGC then validly terminated in response to the repudiation, as the Tribunal has found to be the case, GPGC is entitled to proceed pursuant to the provisions of Clause 25(e) of the EPA and to require payment of the early termination fee.
Early termination payment. 497. In addition to the parties' own submissions, the Tribunal received the written and oral evidence of Ms. Ellen Smith, Mr. Richard Opong Mensah, and Mr. Ebenezer Biden. 498. Ms. Smith is a senior managing director of FTI Consulting and the author of 2 expert reports filed in these proceedings by GPGC. She is a power systems engineer with more than 35 years of operational experience in the energy sector, working in the electric power industry, including nearly 20 years of experience at GE, the original equipment manufacturer of the major equipment comprising the GPGC equipment. She has a detailed knowledge of all facets of GE's power plants, including the particular LM6000 aeroderivative power plants in issue in this case, including project development, design, engineering, procurement, installation, construction, operations and maintenance, and project and plant management. The propositions advanced in her reports were supported, inter alia, by GELM 6000 fleet operational data, the purchase orders and invoice records, and the KPMG audited GPGC financials in respect of the mobilization costs claimed. Neither Ms. Smith's calculation of the total mobilization costs, nor the underlying records have been contested, and the detailed costs estimates and proposals received in respect of any prospective demobilization. Her standing as an independent expert was not questioned, and she was, in the opinion of the tribunal, an impressive and credible witness. 499. Mr. Opong Mensah was put forward by GOG as an expert witness on the early termination payment, but his independence and his expertise are open to question. He confirmed to the tribunal that he had retired as a director of VRA in November 2019, within 2 or 3 months of submitting his report in this arbitration. At VRA, he had reported to the Deputy Chief Executive, Engineering and 534 Operations, who, in turn, had reported to the Chief Executive, an appointee of the President of Ghana. 3 particular points emerged from his short cross-examination. First, although part of his remit had been to comment upon the guaranteed capacity and the availability of the GPGC equipment, he acknowledged that he had not been provided with a full copy of the EPA. Specifically, he confirmed that he had not seen Annex 1, which contained the equipment specifications at the time that he had produced his 535 report. Second, Mr. Opong Mensah confirmed to the tribunal that he had only become aware of Ms. Smith's second of 13 March 2020, in which she had disagreed with the opinions set out in his own report of 30 August 2019, in the week before the 536 hearing, and to which he had had no opportunity to reply. Third, Mr. Opong Mensah had stated in his report that he would 537 require access to the site in order to undertake a thorough technical audit to assess and verify the costs claimed by GPGC. He 538 confirmed that he had asked GOG and its counsel to request site access of GPGC. It was suggested to him that no such request had been made of GPGC, but while he was unsure whether or not a request had been made, Mr. Opong Mensah stated that he had gained access to the site in November 2019. When it was made clear to him that GPGC had no knowledge of his visit, he replied, "I accessed their site, but they wouldn't know that I was the expert for GOG. He security gave me access when I told I was the 539 staff of VRA. 500. But whatever assessment Mr. Opong Mensah may have carried out, it did not result in any further challenge on his part to GPGC's 540 costs claim or Ms. Smith's evaluation of it. 501. Mr. Biden is an employee of the Electricity Company of Ghana. Although it was suggested that his evidence would be invaluable, in light of his advisory support to GOG in the course of the negotiations leading to the conclusion of the EPA, Mr. Biden conceded that he had proffered no documentary evidence to support his assertions. More to the point, when his attention was drawn to the fact that he had twice referenced GOG's estimate of the total cost of its termination of the EPA in the event that the tribunal were to uphold 541 GPGC's claim, he confirmed that he was speaking for GOG rather than proposing an estimate of his own. In short, he was an advocate for GOG and not an expert proffering an independent opinion. 502. So far as his evidence about the early termination payment was concerned, the tribunal must conclude that it was of little, if any, probative value. First, he maintained that the minimum availability criterion of 92% was the appropriate measure for contracted availability. 2. Notwithstanding the provision in the EPA of a commercial incentive to achieve maximum availability, which, in the case of the LM 6000 gas turbines, was close to 100% at 99.8%. Mr. Biden insisted that in real-time working conditions, there was no basis to assume that GPGC would always go for the incentive and experience of the operation of other GE turbines in Ghana. 542. Suggested that none had achieved a performance substantially above the 92% threshold. 503. Second, he sought to suggest that the terms guaranteed capacity and guaranteed availability were interchangeable, not a point he had taken in his written evidence and which flew in the face of GOG's pleaded case that the terms could not be swapped and that GOG 543 had not used them interchangeably. 504. Third, he acknowledged that a. The EPA made no provision for a discount factor in the context of the early termination fee. B. Mr. Opong Mensa had not proposed the application of a discount. C. GOG had not applied a discount rate to its own calculation of the early termination fee, and D. He had provided neither an explanation of the calculation of any such discount, nor adduced any documentary evidence to support 544. It. 505. Fourth, whilst in his written evidence, he had maintained, as had GOG, that the issue over GPGC's claim for demobilization costs turned on quantum, $6.46 million United States dollars as claimed by GPGC against $3.6 million United States dollars as asserted by GOG, rather than upon any 545. Entitlement to claim such costs. In the course of his cross-examination, he suggested that he disputed GPGC's entitlement to such 546 costs, too, because the plant had not been constructed in Ghana. To the extent that Mr. Biden did consider the quantum of the claim, he maintained that the assessment of $3.6 million United States dollars came from records provided by GPGC to GOG during the negotiations for the EPA on the cost to be incurred when the power plant was disassembled in Italy and brought to Ghana. Mr. Biden accepted that none of that documentation had been produced to enable the figures to be verified and, in any event, when it was put to him that the costs of demobilization in Italy in 2015 would not be the same as the costs of demobilization in Ghana in 2020, he suggested that the 547 latter costs would be less, but he adduced no materials upon the basis of which that proposition could be tested. 506. In light of the above, the tribunal concludes that the evidence of Ms. Smith is to be preferred to that of Mr. Opong Mensa and Mr. Biden. 507. The early termination payment comprises 4 elements. The early termination fee more precisely defined in Clause 25b(I) of the EPA, together with mobilization and/or demobilization costs as applicable, and any other costs reasonably incurred by GPGC is a 548. Result of an early termination. Early termination fee Clause 25b(I). 508. Article 25b(I) provides, in relevant part, if this agreement is terminated by GPGC due to GOG's breach of its obligations under the agreement or GOG's default, or GOG terminates the agreement contrary to the provisions of the agreement, GOG shall pay an early termination fee of an amount equal to 549. Capital recovery charge multiplied with the amount of energy the GPGC equipment would have produced, if the GPGC equipment continued to operate, at the guaranteed capacity, for the remaining term, the early termination payment, up to a maximum of 24 months within 90 days after issuing of the termination notice by GPGC. 509. 550. GPGC's assessment of the early termination fee is $69,361,680 United States dollars. 510. So far as the first input, the capital recovery charge, is concerned, it is common ground between the parties that it is fixed at 3.7 US cents per kilowatt-hour, 37 United States dollars per megawatt-hour pursuant to Annex 3 of the EPA. More contentious is the second element, the question of the amount of power the GPGC power plants would have produced, had they continued to operate at the guaranteed capacity over 24 months. Guaranteed capacity of the GPGC plants. 511. Guaranteed capacity is not a defined term in the EPA. GPGC says that it should be interpreted by reference to Recital G of the EPA, the parties wish to enter into this EPA to govern the relationship for the supply of up to 107 megawatts ISO installed capacity power from the two combined cycle power plants, and to the operating specifications in Annex 2 of the EPA. Contracted capacity shall mean 80 megawatts in simple cycle mode and 107 megawatts in combined cycle mode. 512. GPGC maintains that guaranteed capacity should be construed by references to the installed capacity of 107 megawatts in ISO conditions. The EPA refers to no other capacity in combined cycle mode and the guarantee conditions prescribed in Annex 2 of the 551. EPA replicated the ISO conditions precisely. 513. GOG says that the guaranteed capacity should not be benchmarked by the ISO capacity specified in the EPA, but rather, it should be 552. Based on actual site operating ambient conditions, i.e., operating temperatures of 29 to 35 degrees Celsius, an operating range to which the EPA makes no reference and, in any event, GOG has not identified what that capacity should be. In fact, GOG itself and its witness, 553. Mr. Biden, both adopt 107 megawatts, the ISO installed capacity, as the guaranteed capacity, and so, at the end of the day, there is nothing between the parties as to guaranteed capacity. 514. GPGC submits that to the extent there is a difference, it is academic and it should be ignored. As Ms. Smith observed, there are good reasons to construe guaranteed capacity as a reference to the 107 megawatt ISO installed capacity, which is the only capacity 554 specified in the contract as a contracted capacity. A. Assumed period of continuous operation. 515. So far as the assumed period of operation is concerned, GPGC says it should be 24 months, some 17,520 hours, as contemplated in Clause 25b(I). For its part, GOG says that allowance must be made for shutdowns for preventative maintenance. It assesses that downtime at 8% of those total hours, nearly 2 months, over the 24-month period. 516. That proposition is challenged by GPGC on the basis that a. Clause 25b(I) makes no provision to factor in downtime in calculating the early termination fee. Rather, it contemplates continuous operation for 2 years, and b. Guaranteed capacity is not the same as guaranteed availability. The 92% guaranteed availability is the warranted minimum availability attributable to the plants, as Mr. Biden accepted in cross-examination. GPGC points out that the EPA was structured such that if the annual availability in an operational year exceeded the guaranteed availability, GPGC was entitled to an incentive 555. Payment of an additional capacity charge for the excess. 517. In fact, the operational data published by the manufacturer, GE, for the LM6000 turbines, which comprise the GPGC equipment, 556, demonstrate that they enjoy a worldwide fleet reliability of 99.8% and an availability rating of 98.7%. That being the case, GPGC submits that there is no reason to read into the language of Clause 25b(I) any constraint on plant availability which the parties had not specified and which would be inconsistent with the actual reliability and availability of the turbines borne out by the manufacturer's published data. Ms. Smith pointed out in the course of her cross-examination that she would be confident, based on her own experience of the operation of these turbines, that 100% availability for continuous operation over a 2-year period was certainly achievable. No downtime for major overhaul was contemplated in that period and, in fact, the GPGC equipment had been 557 delivered to Ghana in as close to new and clean condition as possible. The tribunal accepts Ms. Smith's opinion that it is reasonable that the parties would have applied the maximum availability of 100% in the context of the early termination fee. 558. Calculation. B. 12% discount. 518. One further point of difference between the parties is the suggestion by Mr. Biden for GOG that a 12% discount should be applied to any early termination fee paid to GPGC, because, it was suggested, GPGC would be receiving 2 years of capital recovery charges $559. An upfront payment. GPGC says that that proposition fails, first, because there is nothing in the EPA to suggest that the parties intended to apply a discount rate to the early termination payment, which is in the nature of a liquidated sum. Second, the 12% number is an arbitrary figure effectively plucked out of the air for which no breakdown or evidence is proffered. Third, in its own 560 calculations of the early termination fee, GOG applied no discount, nor is there any suggestion on the part of Mr. Opong Mensa that any discount should be applied. 519. The tribunal considers that no compelling case has been made for the imposition of a discount of 12%, or any discount. It concludes that GPGC is entitled to the recovery of the full early termination fee of $69,361,680 United States dollars. Mobilization costs. 520. GPGC urges on the tribunal the point that since the EPA is a tolling or throughput contract, GPGC would not begin to earn the contractual tariff, and thereby to recoup its substantial incurred project costs and to generate a return, until the GPGC equipment achieved commercial operation. That tariff was predetermined. It was not based on costs actually incurred. Hence GPGC says that it had no incentive to spend anything more than was necessary to achieve commercial operation. GPGC suggests that that of itself should provide some reassurance that it would not have incurred costs unreasonably, and such costs as it did incur are supported by a substantial documentary record, including materials audited by KPMG. GPGC insists, too, on the point that the purchase cost of the GPGC equipment, some $40 million United States dollars, including the power plant's turbines themselves, which remain the property of GPGC, is $561. Not included in the claimed mobilization costs. 521. In her first report, Ms. Smith had concluded that GPGC had incurred mobilization costs of $40,223,260 United States dollars, excluding debt finance costs. For the purposes of her second report, Ms. Smith was able to review the independently audited GPGC financial statements for 2016-2018 and to confirm that, as of the 30th of September 2018, GPGC had incurred $18,268,745 United States dollars of debt financing costs on amounts borrowed during the mobilization of the GPGC equipment. The incorporation of those debt financing costs into the overall 562 mobilization costs increases the total to $58,492,005 United States dollars. 522. Rather than challenge the figures as figures, GOG takes the primary position that the mobilization costs should not have been incurred at all, and hence they are not recoverable, but that thesis has been rejected by the tribunal. 523. 563. Mobilization costs is not a defined term in the EPA, nor, as Ms. Smith explained, is there a standardized industry definition. To the extent that it acknowledged that they are relevant at all, GOG would argue for a narrow interpretation, such that such costs should be limited to costs incurred on activities before any works were undertaken on site, in other words, only transportation and delivery costs. That approach, adopted by Mr. Opong Mensa, was disputed by Ms. Smith. She stated her opinion that first, Mr. Opong Mensa's view was inconsistent with industry practice and, second, the meaning of mobilization depends on the context of 564. Each specific project and the parties' contractual relationship. The criteria that might apply in the case of the straightforward supply of plant to a power station are an opposite in the case of a full-scope tolling agreement, which calls for the supply, installation, commissioning, operation and maintenance of the power plants. 524. GOG also seeks to suggest that a recovery in respect of the discrete mobilization costs claim would amount to paying GPGC twice. Mr. Opong Mensah's assumption of double recovery is predicated on the basis that capital expenditure had already been counted in the so-called capital recovery charge component of the early termination fee. However, that assumption is wrong. Ms. Smith points out that while it is true that, in the ordinary performance of the EPA, the capital recovery charge would cover both capital expenditure and profits over the 4-year contract term after the full commercial operation date, the early termination fee calculation halves the operational period considered in the capital recovery charge to just 2 years, instead of the full 4-year contract term. The capital recovery charge is computed in the early termination fee was designed only to cover the foregone profits that GPGC would not receive due to early termination of the EPA, while the separate mobilization costs component of the ETP was intended to cover 565 capital costs in the event of early termination. 525. GPGC says that there is no overlap. The mobilization costs component of the early termination payment reflected costs reasonably incurred and for which GPGC was already out of pocket, whereas the early termination fee related to profits that GPGC had foregone by reason of the early termination of the EPA. 526. The tribunal concludes that GPGC has made good its entitlement to mobilization costs as determined by Ms. Smith, and it awards GPGC the claimed sum of $58,492,005 United States dollars. Demobilization costs. 527. GOG accepts that if it is found liable for wrongful termination of the EPA, then GPGC is entitled to recovery in respect of its eventual 566 demobilization costs. The issue between the parties is the likely quantum of those costs. Ms. Smith estimates them at $6,462,528 United States dollars, including a 15% contingency. Mr. Biden suggests a figure of $3,600,000 United States dollars. 528. Mr. Biden's challenge to quantum is unsustainable, as the tribunal has noted at paragraph 505 above. He acknowledged that his opinion was based on supposed records of the costs of dismantling the GPGC equipment in Italy and transporting it to Ghana, considered between the parties during the negotiation of the EPA in 2015. None of these records was before the tribunal, and it is difficult to see what relevance they might have to the likely costs of demobilization of the GPGC equipment in Ghana in late 2020, early 2021. 529. What is before the tribunal is Ms. Smith's analysis, which, as at the date of her second report, the 13th of March 2020, was based on quotations received by GPGC from different contractors by reference to the actual anticipated scope of work and costs to be incurred. Whether or not Mr. Opong Mensah's clandestine site visit in November 2019 allowed him to undertake a thorough technical 567 audit is not clear, but he has not presented any figures to contradict those put forward by Ms. Smith on the basis of quotations in 568. Work estimates from independent suppliers. 530. GPGC's entitlement to demobilization costs is not an issue, and on the basis of the evidence before it, the tribunal adopts the quantum assessment of Ms. Smith and awards GPGC $6,462,528 United States dollars. Other costs reasonably incurred. Preservation and maintenance costs. 531. These costs are the preservation and maintenance costs incurred by GPGC pending demobilization and which were assessed at 569 United States dollars. 32,448 in Ms. Smith's first report. In her second report, Ms. Smith notes that GPGC has incurred additional preservation and maintenance costs amounting to 847,156 United States dollars. GPGC does not seek to recover these additional sums from GOG, as they acknowledge that the costs were incurred on the basis of a business decision to keep the GPGC equipment in situ whilst the parties attempted to 570 find an amicable conclusion to the dispute. GPGC does maintain its original claim for $32,448. Mr. Opong Mensa had sought to argue that an element of these costs related to land lease costs which had already been factored into the buildup of mobilization costs, and so the costs had been double counted. For the reasons that Ms. Smith sets out in paragraphs 55 and 56 of her second report, that criticism is misconceived. Accordingly, the tribunal awards GPGC the claimed preservation and maintenance costs in the sum of $32,448. Conclusion. 532. On the basis of the findings and reasoning set out above, the tribunal awards GPGC a total of $134,348,661 in respect of its early termination payment claim. 11. Interest. 533. GPGC maintains that it is entitled to pre- and post-award interest. It submits that the tribunal may award both pre-award and post. 571. Award interest under the English Arbitration Act 1996. 534. With reference to the rate of interest to accrue on any amounts owing under the EPA, such as the early termination payment, that are not paid in a timely manner, GPGC states that the relevant provisions of the EPA are the definition of applicable rate and Clause 11(o) of the EPA. 535. In light of these provisions, GPGC says that it is entitled to pre-award interest on the full value of the early termination payment. 572. Accruing daily and compounded monthly, at the rate of LIBOR for 6-month US dollar deposits plus 6%, 6%. 536. As to the date due for payment, on the basis of the fact that Clause 25(b)(i) of the EPA provides that the early termination 573 payment claimed by GPGC was due, within 90 days after issuing of the termination notice by GPGC, and the CL. Termination notice is dated 13 August 2018, the early termination payment was due by the 11th of November 2018 and interest started to 574. Accrue from the 12th of November 2018. GPGC maintains that the pre-award interest on the full value of the early termination payment 575 that it claims through to the date of the CL. Reply, i.e., the 13th of March 2020, stands at $17,074,403. 537. GPGC states that, to the extent that GOG does not immediately satisfy the sums payable under any award eventually issued by this tribunal, GPGC is also entitled to post-award interest accruing from the date of the tribunal's award until payment is made in full under Article 49(4) of the English Arbitration Act 1996. GPGC seeks post-award interest on all amounts, including pre-award interest and costs, awarded to GPGC, accruing daily and compounded monthly, at the rate of LIBOR for 6-month US dollar deposits plus 6,576%, 6% from the date of the award until payment. 538. With specific reference to the costs incurred by GPGC in the arbitration, GPGC considers that these costs constitute an amount due from GOG to GPGC under this agreement, specifically, under Clause 28 of the EPA. Therefore, GPGC claims post-award interest on any costs awarded by the tribunal until full payment thereof, at the same rate as that which is to be applied to the other components 577 of the compensation which they claim. 539. For its part, GOG states that it is inconceivable for the claimant to claim interest from the respondent for its breaches which resulted in the termination of the 578 EPA by the respondent. Clause 11(o) of the EPA does not inure in favor of the claimant. 540. GOG maintains that, prior to the CL termination notice, it had already exercised its right under Clause 25(b)(e) of the EPA and 579 terminated the EPA, thereby rendering the CL Termination notice, redundant and moot. 541. GOG further says that, in the unlikely event that the tribunal were to find that the CL termination notice terminated the EPA, it would contend that upon careful evaluation, Clause 11(o) of the EPA is not applicable to the calculation of interest upon the early 580 termination payment under Clause 25(b)(i) of the EPA. In particular, GOG observes that under Clause 11 of the EPA, which deals specifically with required payments, as defined in the EPA, any required payment shall be made within 60 days, after which interest will accrue under Clause 11(o) of the EPA. Furthermore, GOG maintains that only once it had failed to honor the required 581 payment would it be saddled with the interest rate prescribed by Clause 11(o) of the EPA. 542. GOG considers that its position is reinforced by Clause 22(a) of the EPA, which specifically identifies the required payment and the early termination payment as separate payment obligations to which the limitations of liability otherwise prescribed by Clause 22 of the EPA are not applicable. 543. The first limb of GOG's objection to GPGC's interest claim is moot, because the tribunal has concluded that GOG's purported termination of the EPA amounted to a repudiation of the contract that GPGC was entitled to, and did, accept, such that it is entitled to payment of the early termination payment pursuant to Clause 22(b)(i) of the EPA, and which the tribunal has assessed at $134,348,661 United States dollars. It is true that although Clause 22(b)(i) sets a 90-day deadline for payment of the early termination payment, no provision is made for the payment of interest or for the rate, or rates, at which any such interest should be paid. 544. There is no limitation in the language of the definition of applicable rate. It relates not only to the required payments, as defined to be paid to GPGC in consideration of the mobilization, installation, operation and maintenance of the GPGC equipment, as well as the provision of the GPGC services Clause 11(a), but, pursuant to Clause 11(o), interest at the applicable rate is payable in respect of a NY amount due from GOG to GPGC under this agreement and remaining unpaid after due date for payment of the same. Emphasis added. 545. Whilst it is true that this sub-clause is embedded within the provision devoted primarily to the required payments, there is no limitation upon the ambit of any amount due from GOG to GPGC under this agreement, and the early termination payment is such an amount. The tribunal notes the absence of an express provision, which either precludes the payment of interest at the applicable rate upon the early termination payment or stipulates a specific alternative rate of interest to be paid in that event. The tribunal considers that the applicable rate should be applied in respect of the outstanding early termination payment from the due date for payment pursuant to the CL termination notice of the 13th of August 2018, the 11th of November 2018, with interest accruing at the applicable rate from the 12th of November 2018 until the date payment is received by GPGC, consistent with Clause 11(o) of the EPA. 546. In view of that finding by the tribunal, there is no need to make any further order for post-award interest, so far as the early termination payment is concerned. The tribunal hesitates to apply so generous a rate as the applicable rate to any award of legal costs that it might make. Instead, it will apply the current 3-month US dollar LIBOR rate, compounded quarterly. 12. Costs. 547. GPGC says that, as at the date of the CL statement of costs, it had reasonably incurred the following categories of costs: I. GPGC's share of the fees and expenses of the tribunal, the PCA and the assistant to the tribunal, the costs of the arbitration, E. Reasonable costs for legal representation and assistance, and E. Reasonable costs of an independent expert. In addition, GPGC will 582. Continue to incur costs in connection with maintaining the Opus 2 platform, until the tribunal directs otherwise. GPGC claims 583. Costs as follows. Advance deposits paid by claimant to the PCA, Section IA. Item amount, in original currency, initial deposit requested in terms of appointment dated the 11th of June 2019 100,000 United States dollars. Supplementary deposit requested by PCA letter dated the 30th of March 2020 175,000 United States dollars. Supplementary deposit requested by PCA letter dated the 13th of October 2020 35,000 United States dollars. Total 310,000 United States dollars. Legal fees and expenses invoiced by 3 Crowns, sections IB1 and ID. Item date amount, in original currency. Fees A. Expenses B. Invoice total A plus B. Invoice 10,003,594 the 30th of May 2019 112,867 British pounds 7,469 British pounds and 94 pence 120,336 British pounds and 94 pence Invoice 10,003,595 the 30th of May 2019 232,301 British pounds and 50 pence 3,305 British pounds and 87 pence 235,607 British pounds and 37 pence Invoice 10,003,807 the 31st of August 2019 338,011 British pounds and 50 pence 3,402 British pounds and 87 pence 341,414 British pounds and 37 pence Invoice 10,004,023 the 30th of November 2019 66,772 British pounds 25 British pounds and 96 pence 66,797 British pounds and 96 pence. Invoice 10,004,320 the 9th of April 2020 587,077 British pounds and 61 pence 12,707 British pounds and 97 pence 599,785 British pounds and 58 pence Invoice 10,004,415 the 13th of May 2020 0 British pounds 3,890 British pounds 3,890 British pounds Invoice 10,004,717 the 29th of September 2020 150,000 British pounds 6,269 British pounds and 59 pence 156,269 British pounds and 59 pence Invoice 10,004,771 the 27th of October 2020 551,563 British pounds and 35 pence 15,175 British pounds and 49 pence 566,738 British pounds and 84 pence Invoice to be issued after the 4th of November 2020 13,388 British pounds 18,347 British pounds and 50 pence 31,735 British pounds and 50 pence total 2,051,980 British pounds and 96 pence 70,595 British pounds and 19 pence 2,122,576 British pounds and 15 pence Legal fees and expenses invoiced by KIMATHI and Partners, Section IB2. Item amount, in original currency. Invoice No. INV GPG 20/1 dated the 11th of October 2019 25,467 Ghanaian cedis and 75 pesewas. Invoice No. INV GPG the 2nd of January 23B dated the 22nd of October 2020 217,203 Ghanaian cedis and 89 pesewas. Total 242,671 Ghanaian cedis and 64 pesewas. Fees and expenses invoiced by FTI, Section IC. Item amount, in original currency. Invoice number 10,030,534 dated the 25th of September 2019 100,000 United States dollars. Invoice number 10,032,925 dated the 31st of March 2020 101,053 United States dollars and 57 cents. Invoice number 10,035,388 dated the 10th of September 2020 $43,876 United States dollars and 25 cents. Invoice number 10,036,043 dated the 23rd of October 2020 $107,123 United States dollars and 75 cents. Total $356,053 United States dollars and 57 cents. 548. 584. The respondent claims costs as follows. 1. Costs incurred by Ministry of Energy. Amount equivalenting Hannah. Sadie, GH, remarks. Tribunal's fees and expenses and PCAs. Charges is $310,000 GH 1,770,379.00 at Bank of Ghana Interbank FX rates the 5th of November 2020 5.7109. Logistics for hearing sessions GH 167,292.50 GH 167,292.50. Production and courier charges for hearing bundle £2,460 GH 18,391.94 at Bank of Ghana Interbank FX rates the 5th of November 2020 7.4764. Hearing room services by Opus 2 £23,127 and 50 pence GH 172,910.44 at Bank of Ghana Interbank FX rates the 5th of November 2020 7.4764. Total GH 2,128,973.88. 372,791 United States dollars and 31 cents at Bank of Ghana Interbank FX rates 05. November 2020 -5.7109. 2. AMOFA and Partners legal fees pre-hearing costs. Fee earner, grade, time, days, total billed, US dollar, Emmanuel AMOFA partner, 9,450,000.00. AFIA Korenkiua NTIM, associate, 5,125,000.00. Gloria Ose Nyam, associate, 4,100,000.00. Total 675,000.00. Grand total US dollar of AMOFA and Partners legal fees, 712,585.00. AMOFA and Partners legal fees, hearing costs. Fee earner, grade, time, hours, total billed, US dollar. Emmanuel AMOFA partner, 3219,200.00. AFIA Korenkiua NTIM, associate, 2710,135.00. Gloria Ose Nyam, associate, 228250.00. Total 37,585.00. 549. GPGC has made deposits in respect of the costs of the arbitration in the aggregate amount of $310,000 United States dollars. It has incurred legal fees and expenses of UK £2,122,576 and 15 pence, $2,880,335 United States dollars and 84 cents at the prevailing exchange rate of UK £1 equals 1,357 United States dollars and 242,671 Ghanaian cedis and 64 pesewas, 42,492 United States dollars and 71 cents at the prevailing exchange rate of 1 United States dollar equals 5.7109 Ghanaian cedis. It has also incurred expert witness fees and expenses of $356,053 United States dollars and 57 cents. The total of those fees and expenses, expressed in US dollar, is $3,278,882 United States dollars and 12 cents. 550. On the basis of the findings in this award, GPGC has prevailed on the merits. The tribunal is satisfied that it is appropriate in this case to apply the costs follow the event principle, recalling, 2, that the costs of the postponement of the hearing fall to be borne by 585. GOG in any event. 551. It orders, first, that the costs of the arbitration be borne in their entirety by GOG. The costs of the arbitration, which total $614,353 are made up as follows. A. Fees and expenses of the arbitral tribunal. Mr. J. W. Rowley, $187,508 Professor Albert Fiajo, $164,153 Mr. John Beachy, CBE, $209,625 B. Fees and expenses of the tribunal secretary. Mr. Niccolo Landi, $28,432 C. Fees and expenses of the PCA, $24,634.95. 586. The share of the costs of the arbitration paid by GPGC, which shall be borne by GOG, is $309,877.74. 552. Second, the tribunal is satisfied that it is appropriate to make a substantial order for the recovery of GPGC's legal costs and expenses. While it recognizes that GPGC chose to retain one of the leading arbitration practices for its representation, the conduct of the proceedings, and notably of the hearing, was both effective and efficient in its use of resource. 553. Thirdly, the tribunal is satisfied that the fees and expenses of GPGC's expert, Ms. Smith, are both reasonable and recoverable. 554. In all the circumstances, the tribunal orders GOG to pay $3 million in respect of GPGC's legal fees and expenses and those of its expert witness. 13. DISPOSITIF. 555. On the basis of the submissions, facts and matters in the record before it, the tribunal finds and hereby awards as follows. 1. Declares that the EPA has been validly terminated by GPGC on account of GOG's repudiatory conduct. 2. Orders GOG to pay to GPGC the full value of the early termination payment, together with mobilization, demobilization and preservation and maintenance costs in the amount of $134,348,661 together also with interest thereon from the 12th of November 2018 until the date of payment, accruing daily and compounded monthly, at the rate of LIBOR for 6-month US dollar deposits plus 6%, 6%. 3. Orders GOG to pay $309,877.74 in respect of the costs of the arbitration, together with $3 million in respect of GPGC's legal representation and the fees and expenses of its expert witness, together with interest on the aggregate amount of $3,309,877.74 at the rate of LIBOR for 3-month US dollar deposits, compounded quarterly. 4. Dismisses GOG's counterclaim for an early termination payment in its entirety. 5. All and any other claims and counterclaims of whatsoever nature are hereby dismissed.